Well, while we're waiting for our panel to assemble, I think this might be a good opportunity for us to recognize this being the eve of the 77th anniversary of the Supreme Court's decision upholding the constitutionality of the National Labor Relations Act.
So we're authorized to be here.
Right.
We'd just like you to know that.
Yeah. It was passed in the middle of the Great Depression, and as you know, it was for the purposes of eliminating substantial obstruction to the free flow of commerce by encouraging the practice and procedure of collective bargaining and by protecting the exercise by workers of full freedom of association, self-organization, designation of representatives of their own choosing. And in the years that followed, the Supreme Court struck down several other pieces of the New Deal legislation, including our act. And then it was viewed that conventional wisdom predicted that the NLRB's fate would be to be gone. But conventional wisdom was wrong. And on April 12, 1937, the Supreme Court decided NLRB v. Jones and Laughlin, upholding the NLRB's the NLRA and changing the landscape of American law. So for years thereafter, the agency used to make a big deal about celebrating Constitutionality Day, and we're bringing it back. So happy Constitutionality Day Eve. Thank you all for your indulgence. Is our next seating group available? Okay, come on up. We have Homer Deakins, Dr. Kate Brofenbrenner, and Melinda Hensel. We are behind schedule. It's my understanding that there are some real scheduling challenges that some people have, and so I'm going to be fairly rigid on my time allocation, so please respect that. Thank you. Proceed,
Thank you,
Mr.
Mr. Chairman and members of the board. I appreciate the opportunity to again appear to discuss the question of the standard to be applied for scheduling elections. One of the most notable things I saw in the proposed new rule was the total silence by the board on a central question in fair elections, and that is the right of employees to make an informed choice whether they wish to be represented by a labor union. No one can dispute the obvious fact that unions tell employees only one side of the story about union representation. They tell them the good things. It's equally clear that most employees know little or nothing about unions. Almost 94% of employees in the private sector are not members of labor unions. It falls on the employers to truthfully and in a non-coercive way to educate employees on the disadvantages of unions. This is the process which the statute sets up to assure employees make an informed choice. The appropriate standard for selecting an election date, I submit, should not be as soon as practicable. The standard should be a date which safeguards against rushing employees into an election where they are unfamiliar with the issues. Senator Kennedy said that would require a minimum of 30 days. In other words, a date assured that the employees may make an informed decision about representation. In the words of Samuel Gompers, time is the most valuable thing on earth. Time to think, time to act, time to extend our fraternal relations. Yet time is exactly what the proposed rules would deny workers in deciding whether they extend their fraternal relationships. In 2010, the average time from petition to election was only 31 days. This is a reasonable range to satisfy election standards. There has never been and should never be an absolute arbitrary rule on the timing of elections. The board's proposal for quickie elections infringes on the employer right of free speech by not permitting the employer ample time to educate employees, or in the words of Mr. Gompers, time to think. And the board offers no reason why granting employees a reasonable period to communicate with employees before an election would be harmful to anyone. There is no balancing of rights required in this instance. There is only one set of rights in the equation. In fact, providing employers with their free speech rights is completely consistent with the purpose of the Act to protect employee rights. There is no justification for quickie elections because of employer misconduct. The proposed rule is virtually silent on the question of the extent to which unlawful conduct is a problem, and the proposed rule suggests no change regarding the board's treatment of unlawful election conduct, nor does the board invite public comment about better ways to remedy these situations. I recognize the fact that there are a number of studies which have advanced the quick election idea to avoid giving employers time to commit unfair labor practices. Those studies have been sharply criticized by management on such grounds as the fact that those studies are basically largely reliant upon the views of union organizers with no input from management. Those issues were dealt with, I think, rather thoroughly in connection with the management comments that were made on the 2011 proposed rule, and I don't go into those any further. But with respect to this issue of unfair labor practices, I think rather than overhauling the board's well-established R-case rules, which by any objective measure have worked, it's the general counsel's responsibility to stop misconduct, including seeking 10J injunctive relief, Gissel orders, and so on. This is not an excuse for depriving law-abiding employers of their right to fully communicate with employees on the union issue. And the only last comment I would make is respect to this idea of giving the unions giving employers notice before they file the petition. And I think it was said this morning that that notice might be given at the beginning of an organizing campaign. I don't think that would make any sense. If you're going to consider such a rule, I think it should be designed on the basis of giving notice to the employer a certain number of days before the petition is filed. I don't advocate that idea, but I think if you're going to consider it, it needs to be designed on the basis of the time frame before the filing of the petition and not when the organizing begins. Organizing campaigns can go on for years. Thank you, Mr. Chairman.
Thank you. Okay.